The following information, material, and content is covered under fair use. This is for commenting, teaching, and training purposes only. Again, this is for commenting, teaching, and training purposes only. This is not intended to be, nor to be construed as, tax advice, financial advice, nor legal advice. If you need any applicable advice, please seek a licensed professional. Do your own due diligence, regardless of who presents the information. All rights, titles, and actions or interests reserved ab initio without prejudice. Hey everyone, this is B with To Be Fruitful Training Group. All praises to the Most High. And today we'll be going over the remedy. Now, what is the remedy, you might ask? Well, many have surmised that it is some form of litigation. Well, what am I talking about? Well, I'm talking about claiming the minor accounts or your minor estates that are connected to that warehouse receipt, that chattel paper, that security instrument, the bill of lading, that certificate of abandoned property that you get the same time you're born. And just so you know, birth means abandoned. So it is a certificate of abandoned property. So that is something there. And I would also check out the Born Alive Infants Protection Act as well. So what I'm referencing is the minor accounts or the minor estate as defined in 31 CFR 363.6. So a lot of people have talked about going to bankruptcy. This isn't necessarily the case, because to this I look to a precedent, Stern versus Marshall. And in this, they quote Charles Dickens. This suit has in the course of time become so complicated that no two lawyers can talk about it for 5 minutes without coming to a total disagreement as to all the premises. Innumerable children have been born into the cause. Innumerable young people have married into it. And sadly, the original parties have died out of it. A long procession of judges has come in and gone out. During that time, and still the suit drags its weary length before the court. So they couldn't even put it in their own words. They had to yet quote Charles Dickens. But that's not the main point that I'd like to make about this. Just details its importance. So you can look into the specifics of the case yourself, but they make a difference between public rights and private rights. And when it connects to a federal program or a federal regulatory, scheme, if you will, it relates to a public right. And if it is not directly against the federal government in connection with a public program under the Fed, then it is not considered a public right. It's considered a private right. End quote. The most recent case in which we considered application of the public rights exception, and the only case in which we have considered that doctrine in the bankruptcy context since Northern Pipeline, is Grand Financiera S.A. versus Nordberg, 492 U.S. 33, 1989. In Grand Financiera, we rejected a bankruptcy trustee's argument that a fraudulent conveyance action filed on behalf of a bankruptcy estate against a non-creditor in a bankruptcy proceeding fell within the, quote, public rights exception. we explained that, quote, if a statutory right is not closely intertwined with a federal regulatory program, Congress has power to enact, and if that right neither belongs to nor exists against the federal government, then it must be adjudicated by an Article III court. And if you're privy to certain things, General Order 100, 14th Amendment, D.C. Acts, 1871, 1878, then you'll know that there's no Article III courts. Continuing. We reasoned that fraudulent conveyance suits were, quote, quintessentially suits at common law that more nearly resemble state law contract claims brought by a bankrupt corporation to augment the bankruptcy estate than they do creditors' hierarchically ordered claims to a pro rata share of the bankruptcy res. As a consequence, we concluded that fraudulent conveyance actions were, quote, more accurately characterized as a private rather than a public right, as we have used those terms in our Article III decisions. So what does this mean? Well, it means that certain conveyances, the way that they held them, were different in nature than the way they purported to be. So that means that certain state law contract claims have to be resolved by the states they were issued in. Meaning, if a contract or a deed or some type of secured collateral in a particular state or territory is held up under that particular state law contract, then it must be resolved by that state law itself. For more information on this, please read the entire article regarding Stern versus Marshall, as it is a U.S. Supreme Court case. So then, if it is resolved by state law, then what court would it be in state law? Well, there are several things. One, you can't sue yourself. Two, you're not really suing another party per se, because most people are considered wards. And so just to rule out some certain things, I have done actions in probate and in the county that I was born in. And as you see here, they dismissed it for want of jurisdiction. Now, what does this mean? If a decedent's estate or a minor's estate is dismissed in the probate court in which the estate has arisen from, what does that mean? Well, it means that the estate was potentially not created under state law, rather administered. However, the rights in succession stem from an earlier, more ancient source, particularly the Cestui Act. So in this instance, it stems from either some federal or ecclesiastical jurisdiction. So if one's identity or estate has been stolen, what can one do? Well, you can change your name to avoid people mistaking who you are versus the criminal that's using your name. So this is something that can be done. If you'd like to find out how to, I would say to do it, or based on what I've done or other people's experiences. Like I said, we do have the private equity weekly workshops where we discuss this type of thing. But just to show you, it is possible. Then what is the remedy if the state does not have everything there? Well, if it's not necessarily a federal issue, rather it is something under a state contract, then I wonder what state has authority to handle these types of things. To this, we look to one particular avenue out of Minnesota Court Rules, General Rules of Practice. Rule 220, Birth Certificates. The Registrar of Titles is authorized to receive for registration of memorials upon any outstanding certificate of title, an official birth certificate pertaining to a registered owner named in said certificate of title, showing the date of birth of said registered owner, providing there is attached to said birth certificate an affidavit of an affiant who states that he or she is familiar with the facts recited, stating that the party named in the said birth certificate is the same party as one of the owners named in said certificate of title, and that thereafter the Registrar of Titles shall treat the said registered owner as having attained the age of majority at a date 18 years after the date of birth shown by said certificate. So what does the Sister KV Act of 1666 tell? If the supposed dead man proved to be alive, then the title is revested. Action for mean profits with interest, provided always that if any person, or 3 persons, shall be evicted out of any lands or tenements by virtue of this act, and afterwards, if such person or persons upon whose life or lives such estate or estates depend shall return again from beyond the seas, or shall on proof in any action be brought for recovery of the same, to be made to be appeared to be living, or to have been living at the time of the eviction, that then, and from thenceforth, the tenant or lessee who is outed out of the same, his or their executors, administrators, or assigns, shall or may re-enter, repossess, have, hold, and enjoy the said lands or tenements in his or their former estate, for and during the life or lives, or so long term as the said person or persons upon whose life or lives the said estate or estates depend shall be living, and also shall upon action or actions, maybe cause of actions, to be brought by him or them against the lessers, reversioners, or tenants in possession, or other persons respectively, which since the time of the said eviction received the profits of the said lands or tenements, recover for damages the full profits of the said lands or tenements, respectively with lawful interest, for and from the time that he or they were outed of the said lands or tenements, and kept or held out of the same by the said lessers, reversioners, tenants, or other persons, who after the said eviction received the profits of the said lands or tenements, or any of them respectively, as well in the case when the said person or persons upon whose life or lives such estate or estates did depend are or shall be dead at the time of bringing of the said action or actions, if the said person or persons were then living. So it details upon a court action.